Good morning. Time is now 10 a.m. and the inquiry is resumed. For anyone new today, my name is Rebecca Sabi. I'm a planning inspector appointed by the Secretary of State to hold this inquiry. Today is the fourth day of the inquiry. Firstly, the usual reminders. Can we have mobile phones and other electronic devices switched to silent, please? The bathrooms are located through the corridor to my right. Fire exits through the doors to the left and follow it down. Are we expecting fire drill today? No fire drill. I aim to break for lunch between 12 and 1 with breaks mid-morning and mid-afternoon. Today, we will hear evidence from the council's witness in relation to planning. Before we begin, I received an email yesterday about site visit itinerary. Could I have an update, please?
Yes, good morning, Mum. So we've, I believe we've agreed an itinerary with all of the parties, and it's marked on a plan for you. And Mrs. Else is going to hand that up, and we're also going to hand up a page from the TA. So this is already in evidence, just showing you where the improvements are, where the footpaths are going to be, where the crossings are going to be. So it's all marked on there, so you can see it when you're on site.
And that's to assist with the site visit.
Yes,
yeah,
to assist
that's fine. Yeah. I have scheduled the site visit for between 10 and 12 on Wednesday morning. However, is there a particular time that parties want me to be there? I'm thinking between 8:30 and 9 to catch the school run. Yeah.
From our point of view, you want to see everything in a representative way, both during the school rush or when people go to work, and then slightly after that as well.
Okay. So I'll aim to be there between 8:30 and 9.
Yes, madam. I'm just checking for the indicative for the inquiry timetable for Wednesday, because that's in the middle of the inquiry. I think we'll have to stick between 8:30 and 9. I think there was.
I'll be in the area
later,
but much longer than that. I'll be doing the route, but I'll aim to be along Barkway Road between 8:30 and 9.
Yes, madam.
Yeah. Okay.
Yeah.
Thank you. Are there any procedural or housekeeping matters anyone would like to raise?
Yes, ma'am. And I do this very reluctantly. We did try to avoid, with credit to Mr. Chung, having to do this, but it would be fairest and probably in your interest for me to hand this up. So this is a new document, and I apologize profusely for providing a new document. In our defense, we only found out about it Tuesday. We checked it yesterday, and I spoke to Mr. Chung and Ms. Else about it. Sorry, we checked it Wednesday, and then yesterday we had a discussion about it. And upon consideration, we'd like to hand this up as an additional inquiry document if you're amenable to that. The reason the parties wish to rely on this, it's a resolution to grant planning permission outside of settlement boundaries for up to 100 dwellings on Turnpike Lane. So I've got the officer's report here. I apologize, it's quite chunky. Yet another reason why we didn't want to hand it up. But as both parties are going to refer to it, it seems fairest to put it before the inquiry.
Okay. When was that made?
The resolution was 21st of April. And the officer's report doesn't have a date, but I imagine it was published the week prior to the committee.
Okay. So why was it not handed earlier?
That's a very good question, ma'am. It was brought to our attention on Tuesday. That's all I can say. I'm not sure why.
Okay.
I share I agree, ma'am. It would have been better to know this in advance.
Yeah. Okay. I understand you've spoken to the appellant side about it. Do you have any objections to
No. In fact, we wish to rely on it to some extent.
Okay.
And yes, it's late, but the usual rule is that things should be submitted on time if they're available. But if they're not available or nobody's aware that they're available, then they can't be submitted.
Okay. Mr. Semakula,
We take no position on this, ma'am.
Mr. Hall.
I don't know where Turnpike Lane is, so
Do you have an objection to me?
I'd like to know if it's inside the wider ZOI.
It's in the district.
It's definitely in the district, yes.
Another town, village.
It's
Eccleford,
definitely another
yeah,
town.
in
It's
that
not
case, it's
Royston.
not within the ZOI, so I have no interest.
Yeah, that's fine. Then.
Yeah,
You've got
there's-
copies for everyone.
I have a copy for you, ma'am. Mr. Chung has a copy, and we will endeavour to get other copies for Mr. Semakula and Mr. Hall.
Okay. Yes. Thank you. Can I have this uploaded as an ID document, please?
And
Okay.
that's it for housekeeping from the council.
Okay, as I mentioned earlier, today is the last day that I'll be accepting any representations from interested parties. So verbally, that is today morning, and written comments by 5 p.m. today, please. Are there any comments any interested parties wish to make? Yes. Could you tell me your name and whether you would be okay to receiving some questions from myself or the main parties?
My name is Richard Houghton,
Could you spell this?
Houghton,
Yep.
and I'm happy to answer any questions from you.
Okay.
Okay, I'd like to present an example of the safety hazard caused by cars parked legally on Barkway Road. On the 25th of September last year, I was proceeding up Barkway Road at about 5:20 p.m. I was driving my white Golf. My wife was in the front passenger seat. Her dog was secured safely in the boot of the car. As we passed the terraced houses on the right-hand side, looking up the hill, and a row of parked cars parked on the road outside these houses, I indicated to turn right onto our driveway and slow to a halt as a Citroen was proceeding down the road. As I waited for the Citroen to pass my car, I glanced in the rear-view mirror. A white Kia proceeding up the hill behind me, instead of slowing, accelerated to clear the parked cars and slammed into the rear of my vehicle at quite some speed, shunting it across the road. Everyone involved in the accident walked away unhurt, including the dog, who was saved by German engineering. The driver of the Kia fully admitted liability, saying he hadn't seen me indicate. In my opinion, the cars parked on the road were in part to blame for the accident. The reluctance of drivers to give way to other road users where parked cars reduce the road to a single lane leads to poor driving practice. In this case, it certainly increased the severity of the accident. Living on Barkway Road, I observe the frequent behaviour of cars accelerating towards oncoming traffic with right-of-way to clear parked cars. After the accident, I contacted the North Hertfordshire Police Force as I wanted the accident to be registered. The police officer was very dismissive of my request, and to my knowledge, because no one was hurt, this accident is not recorded in any safety statistics. Thus, in my experience, I would conclude that any traffic safety statistics presented are likely to be a significant underestimation of the true number of accidents on Barkway Road.
Thank you. Thank you. Is there anyone else who would like to? Yes. I
Good
did
morning.
hear from you before, didn't I? Could you just remind me of your name, please?
It's Paul Taylor,
Yes.
and I live at the top of the Barkway Road.
Mhm.
the first thing I'm going to bring up is about the junction that comes out onto the Barkway Road from the site. As you come up the Barkway Road, there's a slight incline and then a slow right-hand bend, and then you're on the junction. So I think as I go up there quite frequently, it's going to be very dangerous because people are going to not be doing 30, they're going to be doing 40 to 60 mile an hour up there, even though it is a 30 mile an hour. It's been said about people walking into town and walking back again, and I think you'll find that people coming back with their shopping will struggle to walk up the hill and into the estate. So I think that would be not many people doing that. The hill on the bike is hard work, and you see people walking them up the hill. I used to ride a 20-inch wheeled folding electric bike and used to do about 8 miles around the town. The last bit of my journey was the Barkway Road, and I had it in first gear and full power and was out of breath and going very slow by the time I got to the top of the hill. Shrubbery Grove entrance will not be used by mothers with prams, and the steps will be very difficult, and most bike riders will find it difficult to lift their bikes up onto these steps as well. Where the road will be going across the 2 fields, they will have to cut down trees, and I don't think this is acceptable in the current climate. The drains are too old to take on these houses as well. I have had trouble with my main drainage outside my boundary as they need cleaning. And I think that will be all the drains down Grange Bottom as well once they put these houses up. Also, with the house being built, this could cause flooding in Grange Bottom because there'll be more water coming down the fields as there'll be more concrete up there. Last bit is going up the Barkway Road, you have the cars parked on the right and then a gap of 2 to 3 cars. The cars then parked on the left. Past Beldham Avenue, up the hill, then the Victorian houses on the right where the gentleman was just talking about, with cars parked outside them. This is dangerous as the cars coming round the bend at the top of the Barkway Road, again, a lot too fast. They then sometimes overtake the cars and you have to stop quick going up the hill. Thank you.
Thank you. Is there anyone else? Yes.
So my name is Richard Jameson. I spoke on Tuesday.
Yes. Yes.
So it was just a point of to clarification, really, I guess. So I listened to Mr. Frisbee's anecdote of him riding his Brompton bike up Greenwalk Plantation. I've lived in that area for 3 years. I walk my dog there every day, and I've spoken to other residents. They've never seen another cyclist on that for obvious reasons, because it doesn't go anywhere and it's very steep and inaccessible. So I just wanted to balance that anecdote with real life experience from the residents that we don't see people on that path. They don't cycle it. It's too steep. They wouldn't do. Thanks.
Thank you. Anyone else? Okay. Pindham, can I invite you to commence your evidence in chief?
Thank you, ma'am. Good morning, Mr. Connell. You are Stephen Connell, a Chartered Town Planner. You are Director of GC Planning Partnership, a planning consultancy that works both for private and public sector clients. You have a degree with honours in town planning, a postgraduate diploma in town planning, and you are a member of the Royal Town Planning Institute with some 24 years experience.
Yes.
And a few questions in chief, Mr. Connell, just starting with the policy context. In terms of consistency of policies, what is your view of the consistency of policies SP5, SP9 and CGB1 of the local plan with the NPPF?
Okay, in terms of SP5, I set that out in my proof at 317. And I'll quickly read that out. It's only one paragraph. SP5 is referred to in reason for refusal 2. This policy provides for a general policy of constraint within the rural areas beyond green belts. It is designed to steer appropriate development to the most suitable locations. In relation to policy CGB1, which is also referred to in reason for refusal 2, it allows for exceptions to the general restrictions to policy. Both of these policies are consistent with the overarching aims of development within the rural areas as set out in the framework. In terms of SP9, that's referred to in reason for refusal 1, and it requires preparation of a strategic master plan for housing developments of over 100 dwellings. And the policy provides a list of requirements. To my mind, the aim of the policy is to ensure proposals are capable of being good design. Design is central to good planning. The need to achieve high quality, sustainable, integrated design is peppered throughout the framework, including paragraph 115, which is also referred to in reason for refusal 1. Therefore, I consider that policy as consistent with the framework. Now, if I go on, obviously, the council cannot meet its 5-year housing land supply. So I acknowledge that paragraph 11D is triggered. However, well, and taking that into consideration with the policy, obviously I can appreciate that reduced weight has to be given to policy. However, in a planning judgment, I need to consider what that is based on the factors that I set out now, which is 1, the development plan is pretty new. It's undergone a full examination, generally quite recent. The policies are based on the general thrust of the framework, that, you know, particularly SP5, insofar as it's not based on an old PPG or PPS or anything like that. It is based on, it's not based on protecting the countryside for its own sake or something like that. So in terms of its general thrust, it's very consistent with up-to-date framework. In terms of Royston, there's 2 housing allocations that still need to be met. So it's still available. 50% of the allocations are still open to be met. The other 50% has planning permission. And the other factor I've taken into consideration is that the council have applied paragraph 11D when it thinks it's appropriate and approved development. So taking a proactive approach, and I've set one out in my proof. There's another one that we've recently just referred to in Turnpike, I think it's Turnpike Lane. That's 100 dwellings in the Greenbelt. So when it's appropriate, taking section 38 into consideration and obviously paragraph 11D, the council have appropriately applied the necessary tests. In terms of the emerging plan, I can advise you as an up-to-date that public notice of intention to commence was set out on the 24th of April. As of Monday, just gone, the scoping consultation started. So putting those factors into consideration, in terms of a reduced weight, yes, I appreciate there's some reduced weight, but I don't think it's a lot at all. And certainly not what's has been alleged or promoted in the appellant's proof. I believe that's very limited weight. I certainly don't consider very limited weight. I would say it is reduced, but not by much at all.
Thank you very much, Mr. Connor. I'm not typing as fast as I'd like.
Sorry.
That's fine. No, that's my apology for that pause there. Okay, the next topic. So that's policy, and thank you for the updates. Thurfield Heath, appreciating you are a planner and not an ecologist, and you are instructor on behalf of the council. You have not been involved in the history of this appeal or consideration of the application. What is the council's position on the potential effects of Thurfield Heath on Thurfield Heath Triple SI and the agreed mitigation?
Okay, as far as I'm aware, and I've been advised, there has been a mitigation strategy submitted. Natural England have been consulted. They agreed a principle, and subject to detail in reserved matters, those matters are acceptable.
There we go. Okay. And second last topic, reasons for refusal. Reasons for refusal 1, if I can summarize that as the transport reason for refusal. Could you please summarize the sustainable transport concerns identified by Mr. Hegarty that you rely on in your planning balance and planning policy terms?
Yeah, thank you. Obviously, I've read Mr. Hegarty's proof in full, and I think it's probably easier if I just I've accepted everything he said in his proof, and I point you specifically to paragraph 520, where he simply sets out his conclusion to that. 520 has 1, 2, 3, 4 points where he considers the LTN 120 hasn't been met. There is deficiencies in the infrastructure in terms of pedestrian cycle ways on that public right of way 009. I've taken all those into consideration in my planning balance.
Thank you. And moving on to reason for refusal 2, can you, I'll be a bit more open about this. How does that relate to the relevant policy? Sorry, I haven't framed that properly at all. Sorry, Mr. Connell. Reason for refusal 2, can you summarize your decision, your consideration of the planning merits or otherwise of that reason for refusal?
I think I've got your question. Okay, if I just set out reason for refusal 2, I think there's common ground that the proposal in principle is contrary to SP 5 and CGB 1. Obviously, I've had to take into consideration insofar as reason for refusal 1, Mr. Hegarty's professional opinion. I've applied his position and taken in consideration paragraph 11D, taking all those balances into consideration, and I've come to the position that, and I set it out in my conclusion. It's probably easier if I just read out my conclusion, really, rather than trying to I think it's probably easier. In my planning balance, I set out the benefits and the harms, and I can go into the planning balance later if you wish. But I set out at 1.10 of my proof, and I say it's acknowledged that the proposal will result in environmental, economic, and social benefits which are afforded due weight. However, when taken cumulatively, but specifically as a result of the harm owing to the lack of connectivity from the alternative sustainable transport modes and the site's location or inappropriateness, it is considered that in this case, the adverse impacts of the scheme would significantly and demonstrably outweigh the benefits. As a consequence, and in accordance with paragraph 11D, the scheme does not benefit from the presumption in favour of sustainable development. So in conclusion, at 1.11, I say that the appeal proposal will therefore conflict with the local plan policies SP9, SP5, CGB1, and therefore the conflict with the development plan as a whole. No material considerations indicate permission should be granted otherwise than in accordance with the development plan. That the last one's sort of both 110.
Summary proof, ma'am.
Ah, yeah. Yes, sorry.
Oh, on my summary proof. So I've just gone straight to the back. Didn't realise the summary proof was there. So 1.10 of my
Yes.
yeah, and it is
Yep, got it. Thank you.
yeah. Okay, sorry about that.
Okay, Mr. Connell. And final question. You mentioned the planning balance. Where things are agreed, we don't need to go into that in the interest of time. Can you please set out for the inspector the differences between yourself and Ms. Else in the planning balance, please?
Yeah. So just to give a brief, in terms of my weighting, I have stuck with the statement of common ground. I haven't moved from that. So any kind of reference I make here is, and I'll point out where it's been agreed in the statement of common grounds. So that might be easier. So in terms of enhanced highway works and enhanced contributions, as far as I see, the appellants have said moderate weight for both. I haven't made any submission on that in my proof or in the statement of common ground. My position now is it's neutral. I suggest it's, they're 106 mitigations rather than putting a benefit to it. Healthcare, the appellants introduce healthcare. Again, I consider that's neutral. That's what I consider to be a 106 mitigation. I wouldn't put any benefit weight to that. The appellants have put employment, jobs and support for shops as separate. I haven't dealt with that. In the statement of common ground, we did economic and sustainable credentials as one. I haven't split into three there. The appellants have said in terms of employment significant and support for shops is moderate. But if you look at statement of common ground, page 26, it sets out that the economic and sustainable credentials is only given moderates. Okay, the appellants have said GI open space is moderate to substantial. Now, to be fair to the appellants, they haven't introduced BNG, whereas I have. So I've taken that to be BNG, so we can be on par really with that. So I accept that to be moderate and taking that to be BNG rather than double counting or anything like that. Because obviously BNG, there is a benefit to there, but the appellants hasn't introduced that, but it is a benefit. The appellants have got landscaping and I've put that as minor. I have considered that to be double counting and consider that to be open space. And that in the statement of common ground is set out to be neutral, page 26. Works to the rights of way, that was set out in the appellant's case as moderate. I didn't deal with that in the proof, but I'm happy to generally accept that. There's nothing in the statement of common ground either, but I'm happy to accept that. However, the appellants have introduced Thetford Heath as a substantial benefit as well. And a lot of that's to do with upgrading rights of way. So I consider that to be a double counting, and any other parts of the Deptford Heath are mitigations. The appellants have suggested archaeology should be minor, but the statement of common ground says, page 19 says it should be neutral. In terms of harm, loss of agricultural land, the appellants say that's minor, but the statement of common ground, page 18, says moderate. In terms of harm and landscape harm, the appellants say minor. Statement of common ground, page 19, says moderate. They're the planning balances. Obviously, I revert back to my conclusion.
And you've addressed the last question I had, Mr. Connell, so thank you very much. Those are my questions. My learned friend will have some for you now.
Oh, sure.
Yes, Mr. Chair.
Oh,
I'm fairly easy either way. I have no.
I am
no
so sorry.
preference.
No, quite right, Mr. Chung. I'm so
No,
sorry.
I have no preference.
Mr. Hall.
So
please.
sorry, Mr. Hall.
good morning.
I'm pleased. Well, I'm not pleased, but I'm mildly amused that you and I both got the description of what this was about. We both got it wrong, and you, like me, thought it was as in the application form and the revised application form that outlined planning for residential development, including affordable housing, with all matters reserved except for access, which is to be and green infrastructure, etc. So at least we both got the same mistake. I'd like to understand. You've already mentioned and you about the planning, the balance in 11D, and the fact that you think it's disengaged by virtue of 11D2. Is that correct?
No.
Sorry, you're not saying that the tilted balance is disengaged by 11D2?
No, the paragraph 11D is engaged.
You've written in your proof at 4.5, consequently, and in accordance with paragraph 11D2 of the MPPF, the proposed scheme does not benefit from the presumption in favour of sustainable development.
Yes.
Would you like to expand on that?
Oh, okay. So let's get my proof. Proof here somewhere. I'm looking for my proof. That's right. You're taking me to which paragraph?
4.5 was the paragraph I thought, well, maybe I've just totally misunderstood what's your meaning of that paragraph, but you said consequently, is about the middle, consequently, and in accordance with paragraph 11D2 of the MPPF, the proposed scheme does not benefit from the presumption in favour of sustainable development.
Yes, so obviously there's no 5-year housing land supply.
Yep.
Okay, so so that engages, and I take that assessment. Does this application, do the benefits of this application outweigh the harms? Yeah. So
Yeah.
what I've come to the conclusion is that no, that's not the case. The harm outweighs the benefits.
Right. When you made your consideration of 11D2, had you already considered 11D1?
No, obviously I read it, but no, I haven't taken that approach.
So it was a case of once you'd found a paragraph that you were happy with, meant that the presumption wasn't in favour of sustainable
No,
development.
I didn't go looking.
You stopped at that point.
No, I didn't go looking for anything else.
Yeah.
Obviously, I'm employed by the council. First of all, I'm asked if I'm willing to defend the council's position on the reasons for refusal presented. I then have to look at that, go on site, assess that. If I'm professionally happy with the argument as set out in that decision notice, then that's what I'll do. If I'm not, I turn the project away and say I'm not happy professionally to do that. So I'm not there to go searching for other things, because that wouldn't be part of my remit.
Right, I understand. Thank you. That's useful. So in paragraph 4.7 of your proof, you say that you agree with the council that a combination of on-site provisions and financial contributions of £350 per unit is still compliant and will mitigate the harm. So that's your opinion. Am I correct?
That's my opinion based on what I've been advised. As I'm not an ecologist, I can't give a professional opinion into that.
And who gave you that advice?
The council, committee
Who?
reports,
Sorry?
the committee reports.
The officers report to the committee.
Yeah, there's no reason for refusal in relation to the mitigation. So I wasn't engaged to defend that, and I wouldn't have been happy to defend it anyway.
Sorry?
I wouldn't have been happy to defend it anyway.
You wouldn't have been happy
No.
to defend it.
If I can just clarify, because I'm a chartered planner and not an ecologist, I wouldn't have been happy to defend that.
The engagement of the tilted balance is not an ecology issue, though, really, is it?
Well, no, it's a planning issue, but I have to take into consideration what's put forward to me, and that's not what I'm given to defend.
Could we turn to the officer's report? Let me start on a slightly different track. I was hoping, Mr. Connell, you'd be able to answer my question about what happened to our request for money for visitor facilities. Because we made a request of the council for 2 strands of financial support. One was in line with the Thurfield Heath mitigation strategy, and the second was because we provide one of the largest and most used recreational facilities in the Royston area. And so we, as a provider of that space, have, but Ma'am, I'll get into a question. Have you been briefed on this at all?
If
I would expect to be.
No.
I understand that there are concerns with respect to the service provided by the council during the application stage. It is more helpful to me, Mr. Hall, if you focus on the planning merits of the scheme rather than the service provided by the council.
Okay. Could we turn to the issue of what was agreed in the heads of terms? Have you seen an agreed heads of terms document between the council and the appellant?
I think this is probably going back to procedure, Mr. Hall. Things have moved on since then. So there's now a unilateral undertaking. Is that what you're referring to?
Well, the officer's report does not say contribution of 350. And at the time Mr. Connell wrote this, he was happy to agree a financial contribution of 350. But
Mr. Connell didn't write the officer's report, Mr. Hall.
no, that's what I'm saying. He only could have referred to the officer's report. The unilateral understanding wasn't available to him. So I'm wanting to know why he puts down a different number to the officer.
Can we focus on the evidence that's before the inquiry during the appeal rather than the application stage, please?
So just to come back to it, you're saying to me that the council has, as a result of the documents that have come out, has agreed with the appellant that 350 is the right number?
Yes, that's what I'm advised. Yes. Yeah. But for me personally, I have a decision notice.
Yeah.
And the decision notice, reason for refusal 1, reason for refusal 2. Reason for refusal 1 related
Yeah, I
to
understand.
the highway stuff. And
Yeah. Yesterday, Mr. Connell, there was some discussion about how many houses were within the wider zone of influence. I'm right in saying, aren't I, that the council agreed common ground about the wider zone of influence with the appellant?
I don't know.
Okay. Could we turn to the statement, your statement of common ground, please?
$9.1, ma'am. Yes.
And in paragraph 4.6 of your proof of evidence, you point the inspector to paragraphs 5.3.8 to 5.3.14. So I'd like to go to those. And in 5.3.9, a wider 5.8 kilometre outer zone of influence is also identified by the mitigation strategy. That's part of this agreement, yeah?
Yes, yeah.
Which, if I can continue, as well as the whole of Royston, this incorporates many of the surrounding villages. So in this statement of common ground, the council has agreed that developments inside Royston and inside the inner zone of influence are within the wider zone.
Yes, whatever's written in this statement of common ground is common ground between the appellants and the council.
Yeah.
So that's the agreement.
Yeah. So we heard yesterday some from Mr. Dr. Simpson, who was uncertain about whether that was common ground and was uncertain whether we referred yesterday to a map, showed that the pieces by Royston, the developments in Royston were part of that wider ZOI. Your view is that this would say that they are?
I don't have a professional view on that.
Yeah.
I can only tell you that
What it says.
but that's what it says.
Yeah, brilliant. Thank you. You also tell me that what's been written is SIL compliant. I'm not a planner, but my understanding of SIL compliance means that something has to be viable. Would you agree?
What do you mean by viable?
If you can't do it, it shouldn't be, it's not SIL compliant.
I'm not sure that's one of the tests, but if you continue, then I'll see where it's going.
Well,
I'm not sure what you mean.
In the SIL document, which we received literally on the first day of this inquiry, and we haven't really had the chance to read it fully yet, when it talks about mitigation to the SSSI, it talks about different things that could come out of it. And I wanted to understand whether it's the council's view that all of those are viable.
All I can tell you in my capacity is I'm told that's SIL compliant.
Okay. You're told, but you hit. It's just the wording. I agree. It's though you're not agreeing. You're just you. That should really read. I'm told.
Oh,
Yeah. I wanted to ask you a question, Mr. Connell, about some other developments, but I think I've already understood that you will be not able to answer it because they're not within the parameters that you've been engaged about. Yeah. Would it surprise you, though, given that your understanding of planning, that developments in the outer zone have been agreed in this room for sums greater than developments in the inner zone?
I have no comment.
I wrestled during my evidence to understand what I termed the policy stack of what is policy and what is guidance. And I wanted to ask you, is a SPD, like the Developer Contributions SPD, policy or guidance?
It's material consideration, so material planning consideration. It's guidance, but that is a material planning consideration. I think sometimes guidance, sometimes it can be policy, but in this situation, it's material planning consideration, it's guidance.
So the whole of the Developer Contributions SPD is just guidance?
Yeah, yes, but it's material planning consideration.
Material plan, yeah, yeah. And why is that distinction important?
Can you elaborate? What? Compared to what?
When undertaking planning decisions, if it's just a material consideration, you can discard it.
You don't discard it. You take it into consideration, and you deal with that in the pot.
Yeah.
So your first point of call is section 38, which is your development plan, and all your development plans, whatever they may be.
Yeah.
And then you have material considerations kind of underneath, if you like, and you take those into consideration as part of that assessment. But your first point of call is a development plan under section 38.
Yeah.
And then you take certain things that may be acceptable in certain situations in a material consideration. They might not even be guidance. It may be something else that's a material planning consideration.
Yeah.
But you put that in the pot. First and foremost is your development plan, and then your planning material considerations underneath. And then you come to a planning judgment.
And that judgment might be to not follow something that is a material consideration.
Yeah.
Yeah. In order to avoid going over things that aren't within Mr. Connell's remit, and not to frustrate you as I seek to understand processes, I think I must conclude there. Thank you.
Thank you, Mr. Hall. I've scheduled. I haven't scheduled a break actually. Should we have a quick 10-minute break and we'll resume at 11? Could you hand? I'll give you an opportunity to hand that to me once I resume. That's okay. Yep. It's 11 o'clock. The inquiry is resumed. Before I invite Mr. Chung for cross-examination, the committee report mentioned earlier has gone up on the portal as ID 7. Can I ask that the site visit itinerary also goes up as ID 8, please? Thank you. Mr. Chung.
Thank you, ma'am. Good morning, Mr. Connell. Let's start with matters that we're agreed about. We're agreed that there's no 5-year housing land supply, and therefore the tilted balance is engaged. It's important, isn't it, Mr. Connell, to not lose sight of what that means. We can agree, can't we, that in a case where the tilted balance is engaged, that in order to refuse permission, it's not sufficient, is it, to show that there will be harm? Harm by itself is not enough, is it?
Correct.
It's not sufficient, is it, Mr. Connell, even to show that the harms outweigh the benefits?
Correct.
You've got to show that the harms significantly and demonstrably outweigh the benefits. There's got to be a clear blue water between the benefits and the level of harm.
Correct.
Thank you very much. Then the next topic I have for you is the role of reasons for refusal. If there is a harm, if a local planning authority identifies a harm that warrants refusal, it should be identified in the reasons for refusal, shouldn't it?
Yes.
If there is a harm, but it's not listed in the reasons for refusal, the inference must be that the local planning authority was of the view that that particular harm was not sufficient to support a reason for refusal.
Yes, in principle, depending on what we're arguing. If there's an overarching kind of statement in the reason for refusal, you could suggest that they were referring to something. Without knowing what you're suggesting, I don't know.
I'm not suggesting anything. I'm simply saying that if a harm is not listed in the reason for refusal, it must follow that the local planning authority didn't think that particular harm was sufficient to support a reason for refusal.
On that question, I'd say it depends. But if I had more detail, I could probably say yes.
Well, it can't depend on anything. It's just a proposition, isn't it, Mr. Connell? So let me explain to you. You're an experienced planner. Somebody at the planning committee says, this development would result in the loss of best and most versatile agricultural land. And the planning officer says, well, I'm afraid I don't think that would be a sustainable reason for refusal. Then there's a discussion. If they felt that it was a sustainable reason for refusal, it would be on the refusal notice, wouldn't it?
Yes, on what you're saying there, I agree.
Yeah. So the only two reasons for refusal that made their way onto the refusal notice were inadequate opportunity to travel by non-car modes, and this is outside the settlement boundary. That's right.
That's correct.
In your proof, at page 18, you identify three harms. So three harms that you rely on. One is the lack of sustainable transport modes, which is in the reasons for refusal. And the other two, the loss of agricultural land and landscape and visual harm. That's it, isn't it? No other harms. This is your page 18.
Yes, they're the planning balance harms. Yes,
Yeah.
but not a reason for refusal.
No. And that's my next question. Neither of those two first harms, the agricultural land and the landscape and visual harm, were considered sufficient by the LPA, either individually or together, to warrant a reason for refusal.
That's correct.
And that's important to bear in mind, isn't it, when we look at the planning balance? Because as you say, at your paragraph 420, the planning balance is not a mathematical exercise, but a single exercise of planning judgment.
Correct.
Yeah. So as part of that single exercise of planning judgment, we must bear in mind that those two harms, the loss of agricultural land, landscape and visual harm, the local planning authority doesn't believe that those two harms would justify refusal.
Yeah, doesn't warrant a reason for refusal. Correct.
So let's then have a look at, because we looked at reason for refusal in one in great detail. I will have some questions about accessibility, but I really don't want to go through everything that the inquiry's heard for so many days. But so let's think about reason for refusal 2, settlement boundaries. We know that the site is outside settlement boundary, that if the development would be contrary to SP5 and CGB1. We're also agreed, aren't we, Mr. Connell, that applying paragraph 11D, that these two policies fall within the basket of policies that are most important for determining the application.
Correct.
And we're also agreed that by virtue of footnote, the footnote to 11D, they are out of date because of the lack of a 5-year housing land supply.
Yes.
So the next question is, well, what weight do we attach to the breach of these policies? And when I read your written evidence, you don't give a direct answer to that, do you? You don't specify the level of weight that you say should be given to breach of settlement boundary policies having regard to the lack of a 5-year housing land supply and the fact that the policies are out of date.
I do refer to the fact that by virtue of there's no 5-year housing land supply, the development plan is out of date.
Yeah.
But I do qualify that by saying, and I go through actually in detail why I think that the policy is still consistent. You're right. I didn't actually give an actual weight in my proof. However, I believe I've qualified that today.
Okay, that's fine. I heard what you said in chief. What you said in chief was, well, the appellant says that they give limited weight to the breach of development settlement boundaries. I don't agree with that. I would reduce the weight, but not all the way to limited. Is that fair?
In fact, in the appellant's proof, it's very limited weight.
Okay, but you say, look, I would reduce it, but I wouldn't go as far as the appellant.
Quite correct. Yes.
Yeah. But just thinking about, we say very limited, and that's our position. You don't agree with it, so I'm just going to press you a bit further. I accept and note that the inspector notes that you do accept that the weight is reduced. It's not full weight, it's reduced weight. But so the argument really between us is very narrow. Is it very limited, or is it something more than very limited? Yeah.
Yes, it's not full weight. It is reduced. I did caveat why it wasn't reduced to the same extent as the appellants.
Yeah,
I set that out. But yeah, I'm not in a position saying it's very limited weight. Certainly not. It is reduced, but not by a lot at all.
right. So let's just explore that. Not for too long, but just a bit. At your paragraph 412, you agreed that the council is granting planning permission for housing outside of settlement boundaries in light of paragraph 11D, don't you?
Sorry, I was just finding.
Yeah, no, carry on, take your time.
Could you say that again? Sorry.
Yeah, so in your paragraph 412, you acknowledge the fact that the council is in fact granting planning permission for housing outside of settlement boundaries because paragraph 11D is engaged.
Yes, that's correct.
And we've had another example today. We've come to our attention that up to 100 houses in the Greenbelt have been granted planning permission outside of the settlement boundary.
Yes.
And the reason for that, the reason that they're doing that, Mr. Connell, is because the authority appreciates, and you as a planner appreciate, that that's the only way to address the 5-year housing land supply shortage, isn't it?
Well, it's certainly not the only way. Obviously, there could be planning permissions on allocated sites, but yes, it is one of the ways. Now, clearly, this is not just a numbers game. I'm not suggesting the appellants are saying that it's not just a numbers game. Let's get the housing figures let's approve everything. You still need that planning judgment, planning balance, taking everything into consideration. Obviously, the development plan is still the primary go-to, even though the trigger of paragraph 11 is engaged, you still have to go to the development plan under section 38.
Yeah, and that's what we're what we're looking at here is in terms of the weight. This is really another material consideration, isn't it? Because we're in 11D, national planning policies, another material consideration. The tilted balance is another material consideration. So that's what we're applying.
Yes.
And in the tilted balance, you've got to have regard to everything,
Yes.
including the breach of local plan policies.
Yes.
And because we've got to have a look at everything, and including the breach of local plan policies, we've got to decide, well, what weight do we attach to the breach of local plan policies if they're out of date?
Yes.
Don't we? Yeah. Now, that's not to say that we don't look at other things. I agree, we do look at other things, and we're going to come on to look at other harms, but we can only do the harms one by one.
Sure.
So if one of the harms you're alleging is, well, there's a breach of the settlement boundary policy, and there is, we've got to ask, well, what weight are we attaching to that? Hence our discussion of limited, more than limited, very limited, whatever it is. Now, so, but you accept, don't you, that in all practical terms, when there's no 5-year housing land supply, the reason, or one of the reasons can be that the allocated sites are not coming forward. They haven't worked in the way that was expected. There's no 5-year housing land supply. So the only way that you're going to address that difficulty is by granting planning permission on unallocated sites, including unallocated sites outside of settlement boundaries.
That's correct. Subject to the planning assessment.
Yeah. And that's why, isn't it, Mr. Connell, that in this sort of situation, you read decision after decision where inspectors and the Secretary of State say, well, in a situation where the development plan is out of date, the breach of policies which restrict the supply of housing get limited weight. You will have come across that yourself, wouldn't you?
There has been occasions, yes. There has been other occasions. In fact, I've actually seen some decisions where the development plan policy, the settlement boundary policy, has been based on the old PPG, where you're protecting the countryside for its own sake. And even then, the policy was given moderate weight. We're not even in that territory. So I have seen on a number of occasions different ways. It obviously depends on what the inspector at the time is weighing up. Obviously,
Yeah.
I can't tell.
No. But let's have a look at, as an example, CD 6.4. CD 6.4. Readers now decided to freeze them. So that's a decision, different district, Wiltshire. But the principle is what I'm interested in. What should happen when there's no 5-year housing land supply and the policies are out of date and someone proposes to develop outside settlement boundaries? If you look at CD 6.4, paragraph 41, aside from the emerging local plan, which has only just been submitted for examination, so let's just pause there, Mr. Connell, and pick up we'll come back to the rest of the paragraph in a moment. The situation in this authority is, and these were some of the reasons you gave for saying that, in your view, the settlement boundary policy should still continue to get some weight, more than very limited weight. You said the development plan is pretty new and undergone a recent examination. Now, yes, but it doesn't matter how new the development plan is it? Does it, Mr. Connell? What matters is whether the relevant policies in that plan are up to date, and they're not, are they?
Well, by virtue of there's a 5-year housing land supply, or lack of one, then the development plan is not up to date, but the policies are consistent with the framework.
No, consistency is another issue. I'm just going through the arguments you put forward. You said the development plan. I agree with you that having settlement boundary policies is consistent with the NPPF. There's nothing in the NPPF that says that you can't have settlement boundary policies. That's fine.
Hmm.
But this is a different debate. This is a debate about you've got them, but your plan is now out of date. Your relevant policies are now out of date.
Yeah.
What weight should we attach to
Yeah.
those settlement boundary policies? And you, one of the reasons you gave for not reducing the weight to very limited in the way that Mrs. Else has done, he said, well, development plan is very new. And I'm putting to you the proposition that newness of the development plan is irrelevant. If you adopt a development plan and it fails immediately, that doesn't rescue you from the fact that development policies are out of date and they're not working, does it?
I disagree, and I'll give you the reason.
Right.
If we were sat here and we had a development plan that was adopted 1995,
Yeah.
I think we'd be talking a different situation. But we're a development plan led system.
Yeah.
We have a development plan that's only recently gone through full examination. There are allocated sites that are still available. And like I say, we are a development plan led system. I think that its age of its development plan is an important factor to consider. Now, I appreciate this inspector may not. The inspector here today may agree with that, may not agree with that. It is up to this inspector to have that planning judgment and make her own decision. And each inspector will have their own way they want to deal with it based on the facts of the case. I don't know what happened in this one. I appreciate you may be taking me to the principal arguments, but that doesn't mean I can't come away from the position she put herself through in terms of saying it's limited weight. I still think on the factors here, the development plan is consistent, and I don't think it should be given limited weight.
Right.
Reduced weight, yes, by virtue of the trigger, but not limited. And I've even given examples that even very old planning policies have also been given moderate weights. And they're based on old PPGs. DM4 essential beds, Uttersford, Wilden. All these policies were based on old PPG 7s, and the inspectors on those ones gave it moderate weight. So in that context, I don't think I'm far off saying, yes, it's reduced weight, but not by a lot.
Right. I understand all of that, Mr. Connell, but yes, there's planning judgment and everyone's got to make their own mind up. But our job is to pursue the arguments that have been made in a rational and logical manner and see whether they stand up to scrutiny, because that's what goes into a planning judgment. And the inspector makes a planning judgment. She will want to know whether the arguments that she's heard, which one of those arguments is the most persuasive. Is it logical? Is it rational? Now, you make reference to other policies, DM4, etc., in other authorities, but I don't have those decisions in front of me. I can't look at them. I don't know what the circumstances were, whether there was a lack of a 5-year housing land supply, etc. I can only look at the argument that you're making to me. And the argument you're making to me is this plan has been recently adopted. And what I'm saying to you is it is not relevant, is it, logically, whether it's recently adopted 10 years ago. All that matters, the reason that we reduce the weight to settlement boundary policies is because the plan is out of date. You can't have a plan which is out of date and then say, oh, because it's new, I'm not going to reduce the weight. That can't follow, can it?
You're right, and I haven't said that.
Yeah.
What I've said is we don't have a 5-year housing land supply, so therefore the 5-year housing, so paragraph 11D bites.
Yeah.
And I've accepted that the policy have to have a reduced weight. I am not with you on that it should be very limited weight. I'm saying it has to be reduced, not by much. My argument on the factors, what I'm arguing is it is a relatively new local plan. So I'm not in agreement with you.
Yeah. Well, I've yet to hear from you, Mr. Connell, what the relevance is of the fact that it's relatively new.
It's because we're a development plan led system and it's a relatively new development plan. likewise, I think I would be with you if this was a 20-year-old development plan. But the council haven't done anything. The housing supply is going to continue to be a problem. The council are nowhere near a new plan. All of those factors come into play. All I'm
Okay.
saying is that they've gone through that process quite recently. It's gone through full examination. We are a development plan led system. I appreciate the trigger,
Yeah.
but the trigger doesn't, MPPF doesn't just trump development plan.
I'm not saying that, Mr. Connell. I hear what you say. We obviously disagree on that. I've given you an opportunity to explain to the inspector why the newness of the plan is relevant to the actual thrust of the argument. But you say it is. You say that the development plan has housing allocations which are still to be brought forward. But that supports our argument, doesn't it, Mr. Connell? Because what it demonstrates is that it was recently adopted, it had housing allocations, and none of them have delivered. This is a plan that's failed immediately, and is subject and was subject to immediate review, wasn't it?
Yeah, I do agree that those allocated sites haven't come forwards. However, two have permission and the other two haven't. Now, if we were in a scenario again that the development plan had allocations, they've all been developed, and the council have a 2.6-year supply, I'd be saying, well, there's a problem. But we are a development plan led system, and there are allocations, and they are the most sustainable sites.
Yeah, well, let's just think about that, Mr. Connell, for a moment. That is to undermine the agreement that this authority only has a 2.6-year supply of housing, isn't it? Because those allocations are there, but if they were of any utility to helping us with the 5-year housing land supply, they'd be in the 5-year housing land supply, wouldn't they?
Yes, I agree with that.
Yeah.
And I think if I could help out the inquiry itself, if we didn't have reason for refusal 1,
Yeah.
and I took the approach, we just had reason for refusal 2.
Yeah.
And I took the approach that I've taken, assessing the development plan. Then we have to assess the triggers, the the paragraph 11D. I think I would find it difficult to argue reason for refusal 2 on its own right.
Right.
But I have reason for refusal 1, and I've done that assessment.
Well, thank you for that. That's helpful, and I think there's only so far we can push this. But since I did take you to paragraph 41 of this decision, I think we should finish that particular line of questioning. I say to you that what we see in 41 is very similar to here. There is an emerging local plan. The existing local plan is out of date. There's an emerging local plan, but as you rightly say, that's at a very, very early stage. Yeah. And other than that, there's no other obvious remedy to the shortfall in the supply. And the reasoning that's set out in paragraph 41 for saying limited weight applies with equal force here.
Yeah, I read the paragraph, and I've only quickly skimmed through this, but I do notice that the core strategies was adopted in 2015.
Yeah.
And it was only an interim.
Yeah. So that goes back to the discussion we've already had. You say that because this plan was adopted recently, that somehow logically connects to what weight you attach to the out-of-date policies. And I say newness has got nothing to do with it. If it's out of date, it's out of date.
I understand
Yeah.
that. Yeah.
Okay. Well, let's leave that with the inspector. But I note the answer that you gave earlier, which is that if the only thing that was wrong with this site was that it's outside of the settlement boundary, then you would find it difficult to argue that permission should be refused.
That's correct. Yes, I think that's a reasonable approach.
Yeah. Just give me one moment. And it's right, isn't it? Just to finish that analysis off, that the officers of the council, obviously they they felt that there was no breach of SP9, so there was no reason for refusal number one, in their mind, right? But even though this was a development outside of settlement boundaries, they were of the view that it complied with the development plan read as a whole, didn't they?
So I just did they think there was no breach of SP9, or did they just do the
Well, my reading of
trigger?
my reading of the report to committee is that they felt that there was no breach of SP9, and Miss Else gives the reference, and I'll give you the reference if you want to turn it up. It's the report to committee at paragraph 4.4206, 4.4206, and where they say that it complies with the development plan as a whole. CD 3.8, isn't it, the report to committee? CD 3.8. Their finding was that it complied with the development plan read as a whole.
Oh, okay. Okay.
Yeah. So, and the reason I ask you this in this context about settlement boundary policies is that because they clearly, my understanding is that this is a plan that has the presumption in favour of sustainable development as one of its policies, doesn't it? SP1.
Yeah.
That's right, isn't it? Yeah. And therefore, when they applied SP1, they had to ask themselves, read as a whole, you then also ask, because the case law tells us, well, what weight do you attach to these policies? And clearly they attach so little weight to the breach of the settlement development boundary policies that they felt that read as a whole, it still complied with the plan because it complied with SP1.
I don't know how much weight they put on their policies because of the tilted balance. I didn't see what weight they did.
Yeah.
They put on that. I didn't see any of reading on that. But in any event, I've come to a different conclusion.
Yeah, well, you come to a different conclusion on SP9 and accessibility, but as you say, you haven't come to a different conclusion on reason for refusal number 2, because you accept that if it wasn't for reason for refusal number 1, there'd be no reason for refusal number 2.
Mm-hmm.
Yeah. Okay, so let's have a look at very briefly reason for refusal number 1. Now, the officers of the council in the report to committee carried out a very detailed assessment of this proposal against the requirements of SP9, including sustainable accessibility, and we know that they concluded there was no breach of this policy.
Sorry, did you ask me? I was flipping the pages. I couldn't hear. Did you?
Yeah, so the officers of the council looked at the requirements of SP9 in a great deal of detail and decided that there was no breach of policies related to accessibility. That's right.
In terms of accessibility,
Yes.
the council officers, no. In terms of no breach of SP9, no.
Yeah, that was there. That was there. I know that you disagree.
Yeah,
I know you disagree.
yeah.
Yeah, I'm simply trying to understand the reasoning here. So they conclude no breach of SP9, and in that they had the support of the local highway authority, Mr. Connell, which we saw described in the local plan as having the primary responsibility for ensuring development is accessible by sustainable modes of transport. Yes?
Yes.
I know you disagree, but even if you're right, and there is a breach of SP9, the breach of this policy cannot be determinative. And I take that word from my learned friend, Ms. Pindham's opening submissions at paragraph 12. Breach of this policy cannot be determinative because you have to assess the merits of the proposal as a whole, applying the tilted balance, don't you?
Yes.
Yeah. So it's a factor that goes into the tilted balance. It can't be determinative in itself, can it?
Policy SP9.
Yeah.
Can you explain that again to me, just so I?
Yeah. So
I don't want to think
I
I'm
was
missing
just
something.
I was just interested in the use of the word determinative by my own friend in our opening submissions. And the point I'm putting to you is that, well, in simple terms, Mr. Connell, there are very few things in planning which are determinative, especially when you're in the tilted balance, because all you can do is put all of the benefits and all of the disadvantages into the tilted balance, and then you carry out that tilted balance exercise. What you can't say is there's a breach of this one policy, that's it, determinative.
I see what you mean. I'm not sure. I don't recall what council said to me. However, your first point of call is your development plan.
Right.
That's your first point of call. So SP9 is your first point of call. And then you say, has there been a breach of a policy? And then we look at, okay, if there has, what's all our other material considerations? And we don't want to be going through this again, but one of the material considerations, it doesn't trump SP9, is the tilted balance. Like I said, it doesn't trump it. SP9 is still the adopted plan. It's still quite a new policy. It conforms with the framework. So as a policy, that is your first point of call. It's not trumped. Then you take the tilted balance. And even if you put less weight on your policy because of a tilted balance, that still doesn't mean that everything else trumps that, because your development plan is still your development plan. That's your primary policy. So even if you have substantial weight on delivery of housing and you've put significant weight to your policy, that doesn't mean substantial beats significant because it's a lower weight, because your development plan is still higher.
Right.
As in section 38.
I'm simply asking you whether you agree that once you've identified a harm, as you have in this case, you've identified the harm by breach of SP9, lack of accessibility, that harm has to be carried forward into the planning balance, doesn't it? It can't be determinative in itself.
On its own?
Yeah.
No.
No. So you carry it forward into the planning balance. So that's my next heading, the planning balance. Now, let's just have a look at the two harms which we agreed didn't justify a reason for refusal. Loss of agricultural land, you say agreed as moderate harm in the statement of common ground, but Mrs. Else in her evidence says it's minor because the loss of such a land is inevitable if housing needs are to be met. And it's right, isn't it, that in the recent resolution to grant planning permission for the 100 houses, the loss of best and most versatile agricultural land was given only a minor weighting, wasn't it? Limited weight.
I haven't seen that, but even if it has, that's not this site, and it's not agreed in the statement of common ground. On this site, it was agreed in the statement of common ground that it's moderate weight, and I referred the inspector to page 18. Yeah. I think it's 6.6.
I accept that Mrs. Els, in her evidence, has revisited some of the weightings, and she will give evidence about that, and she'll have to answer questions as to why she's given the weight that she has, and the context of the statement of common ground. And the inspector will have to hear her evidence and hear her cross-examination and decide what weight she attaches to these things. But in terms of the evidence in front of the inquiry, certainly in her evidence, Mrs. Els says limited weight. I say to you that in terms of what weight one attaches to the loss of best and most versatile agricultural land, that must be the same from case to case, unless you're saying that the amount of land lost in this case is greater than the land lost in the Turnpike Lane case. There's got to be some consistency, hasn't there? It's a matter of principle.
It's going to be very difficult for each case officer to be that consistent because they're dealing with I don't know what it could be. I don't know if it's the grade, it could be the size, it could be and mounted developable sites. It could be how much open space they're providing. All of those things factored in. I appreciate that you may be thinking, well, if we're going to deliver housing, it has to be on a greenfield site somewhere, but you still have to go through that whole planning process and assess the benefits and harms. So,
No, I agree. You got to assess the benefits and harms. Of course, you have. The question is, what weight should we be attaching to the loss of agricultural land in an area where clearly it's inevitable that if you're going to meet your housing needs, you're going to lose agricultural land, and also a local planning authority which appears to attach one level of weight in one case and another level of weight in another case to the same harm. That can't be right, can it?
I think it's perfectly right. It's exactly right. I wouldn't expect anyone to say, well, old Mr. So-and-so said a landscape loss of agricultural land over here is minor. Well, I better just put minor on my one then. I want them to assess it properly if it was
But why
the
not?
manager.
Why would you? So are you suggesting to the inspector that in the same authority, the planning officers looking at two applications which will involve the loss of agricultural land, they can attach completely different weightings without reference to anything logical or rational? I mean, I can understand if the argument was, well, in case A, you're going to lose 50 hectares of best and most versatile agricultural land, and in case 2, you're only going to lose 5 hectares. Now, that would be a logical argument, yeah? But that's not what's been done here, is it, Mr. Connell?
I don't know the ins and outs of that scheme.
Right.
But I'll tell you what I do know, and that is that in a statement of common ground between myself and the appellants, we both agreed it's moderate in this case.
Okay. Well, I'll ask Mrs. Else about that. You've not been able to answer my question related to inconsistency. In terms of landscape and visual harm, you say that it's agreed in the statement of common ground as moderate. Mrs. L says, well, that's not her understanding of the statement of common ground. If you look at PDF 21 of the statement of common ground.
Yeah.
1 second while I find it. So, in the areas of disagreement, says the council's independent landscape consultation alleges that the scheme will result in a major moderate adverse impact on the localised and wider landscape at year 10. The appellant maintains the significance of this impact is minor adverse at year 10. So she's saying that her understanding of the statement of common ground is that there's a disagreement. The authority says moderate weight, but she says minor.
Yeah. Okay. Well, if you turn to page 19, number 17, which is under the table. It's in the same. So what you're referring to is page 18 under the landscape and visual impacts.
Right.
You turn the page to number 17 when it talks about the planning balance.
Are we talking about PDF pages or the?
Sorry, I'm on normal hard copy pages.
Page 17, thank you.
No, not 17. So I think you're referring to page 18, what you're saying there.
Yeah.
And then if you turn to page 18 and the last paragraph in that table, number 17, it says the identified visual and landscape and harm should be attributed moderate weight in a planning balance.
Yes, I see that. But it's a question of how you, and I'll get Mrs. Else to talk about this, but you have the areas of agreement and then you have the column areas of disagreement, and you've got to read them both together, haven't you?
Well, I'm only reading, put the disagreements to one side. That's a disagreement. Let's talk about the agreement. The agreement is moderate weight in the statement of common ground.
Yeah, but the areas of disagreement is made clear by the appellant that they maintain that the significance of this impact is minor adverse at year 10.
In fact, the council's is it the council's independent landscape? So said it was moderate adverse impact on the localised area. Significance of this impact is minor, adverse at year 10. So it was given a range of different things there. But ultimately, areas of agreement, not disagreement, under 17 was moderate weight. I can only go with what we've agreed.
Right. Well, it comes down to how we read the statement of common ground. But ultimately, what the inspector has to note is that there's a disagreement between what you say and what Mrs. L says, because that's in a proof of evidence. She reads the statement of common ground differently and gives her own assessment of what she says the harm is. So those are the two harms which did not warrant a reason for refusal: agricultural loss of agricultural land and landscape and visual harm. And then there's just a miscellaneous point in terms of harms, which is your paragraph 4.28, please, Mr. Connell. Your paragraph 4.28. You're talking there about sustainable modes of transport. And you say that this harm is considered so substantial that it warrants, in part, the refusal of planning permission. We've now established that it's not in part, it's the sole reason, because you've said that if not for that harm, it'd be difficult to refuse planning permission, because that's the only real substantive harm identified in the reason for refusal.
That's not quite what I said. What I said was, if there was no number one, number two doesn't fall away, you still have to do that approach. But I do have reason for refusal 1, and therefore I still have reason for refusal 2.
Yes, I understand that. But you say this harm is warranted in part the refusal of planning permission, but it must logically follow, if you accept that if not for the harm alleged under reason for refusal 1, permission would have been granted, wouldn't it?
I don't know if well, it's difficult to say. I'm assuming yes, because the officer's recommendation was approval, but I don't know what the council members would have said.
But that's your opinion. That's your opinion, though, isn't it, as well?
My opinion is, if there was no 1, and I'm trying to be as given my professional opinion,
Yeah, no,
I don't think I could realistically defend reason for refusal 2.
Yeah.
So what I'm trying to say is, if there was no reason for refusal 1, and this was refused just on outside of settlement policy arguments, I don't think I'd be here today. I think I'd have to say, I'm sorry, I don't think I can defend that one. However, I do have reason for refusal 1, and I do think that the harm is substantial, it's demonstrable, and it doesn't outweigh those benefits, and therefore number 2 still kicks in then.
Right. Okay. Well, I'll leave that with the inspector. The reason I turned to this paragraph actually to begin with was to ask you a question about the last sentence. You said the site is not locationally appropriate given its lack of reasonable connectivity to alternative sustainable modes of transport. The grant of planning permission would undermine the strategic approach of the development plan process. And it's that last sentence I didn't quite understand. We know that Royston itself is a sustainable location, don't we? In terms of the strategy of the plan, the strategy of the plan is to identify the sustainable settlements, and Royston is one of the most sustainable settlements, isn't it?
Royston, yes, it is.
Yeah. So there's no objection to directing housing to Royston. What your objection is that this is Royston is sustainably located, but the site is not sustainably located in its relationship with Royston in terms of sustainable modes of transport.
So what I'm saying is, on the back of number 1, reason for refusal 1, and I don't want to go over the development plan process again. What I'm saying is that there has been a development plan which is adopted. It's quite new. I believe that actually approving this development, given that harm in terms of the sustainable modes of transport arguments that have been set out earlier in the week, I believe that this is not a sustainable location, albeit Royston is a sustainable location.
Right. Okay. So let's just then focus on this lack of accessibility as which is your case. We know if you turn up CD 3.8 and look at paragraph 4.3.136, which is on PDF page 50. Conclusion on highways and access.
Sorry, just finding the CD 3.8.
3.8, the report to committee, the consolidated report to committee.
Okay, so this is the is this a September one or October one?
I don't. I've simply got CD 3.8.
Fine.
It's headed consolidated report to committee,
Fine.
and I'm on PDF page 50, and there are no page numbers in the time-honored fashion of reports to committee, but there is a paragraph number which is 4.3.136.
4.3.136. 4.3 4.3
and then 136.
136. Right. Okay, conclusion on highway and access impacts.
Yeah. Now, you have in front of you the inspector as well. All you have to do is to scroll back a bit and you'll see that there's several pages devoted by the planning officers to this issue of highways and access impacts. And it is on any measure, a very detailed assessment, isn't it, of the access impacts of this development measured against the various strands of SP9.
Yes, it's very detailed.
Yeah. And the conclusion that they reach right at the end, 43136 on the last, the proposal will result in harm, although in the context of MPPF, this is not considered to be severe, because they, in this paragraph, they're looking at both severe 116 and access, the two. Because we just have to remind ourselves, don't we, Mr. Connell, that as far as 116 is concerned, severe impact, that's no part of the local planning authority's case, but access or lack of accessibility is. Yeah. That's right.
Very, very, very specific to the non-transport.
Yeah, non-transport modes. And in this paragraph, the officers are looking at both. And they then conclude this harm weighs moderate in the planning balance. You see that?
Yes.
Okay. So it's not as though the planning officers decided that this was the most accessible site in the world. They said, yes, there will be some harm. It's not ideal. You'll remember Mr. Hegarty used the word ideal a number of times, not ideal. And they gave it a moderate weighting in the planning balance. But what you've done is to move that moderate up to substantial, haven't you? Top of the scale.
I've moved it to a reason for refusal. So not only is it just a harm, you could have substantial harm and still doesn't meet a reason for refusal. I'm saying it warrants a reason for refusal.
No, I'm more interested in weighting, Mr.
Yeah.
And it's right, isn't it? They did do a weighting of what weight they want to attach to this, and they attached it a moderate weighting, and you have in your planning balance attached it a substantial, haven't you?
It's so substantial it warrants a reason for refusal.
Yeah. Now, in terms of the evidence that you've looked at, you have Mr. Hegarty's evidence in terms of what he says are the shortcomings in terms of sustainable modes of transport. But that is one input into a planning judgment, isn't it, Mr. Connell? It is not the whole of the planning judgment, is it?
No, you're correct. Yes.
Yeah. And it's also right that accessibility by non-car modes is only one strand of sustainability, isn't it?
Yes.
And neither is it a pass-fail test, is it? It's a continuum. Some sites will be more accessible by non-car modes than others.
Yes, in principle, yes.
Yeah. And we saw that in this case. I don't want to go over all of that evidence again, but the evidence shows, and I think Mr. Hegarty to some extent accepted this, the inspector will have her own note. Yes, there is a challenge as far as the gradient is concerned, but the choice is there for many, even if not for all.
Um, I'm not sure he concluded that way.
Well, let's put to one side what he said, because the inspector will have a note on that. I've done this game long enough to know that once you start arguing about what a witness said, you never get anywhere. Yeah. So the inspector has a note of where we got to with his cross-examination. But you are the planner. You have to take his evidence and you have to put it through the lens of that overall single planning judgment, as you rightly call it. And you must agree that the choice is there for many, if not for all. Are you suggesting that nobody will walk, nobody will cycle? It's a continuum, isn't it?
I thought about this quite a lot, actually. And I've felt that a lot of things came out of examination was all to do with the kind of human scale in terms of, well, some people go over here, or if someone's got a disability, they can go over there. And I thought, well, that's just not how we really deal with things. We're dealing with planning policies and guidance. We know that the common.
Sorry, Mr. Connell. Could I have a yes or no and then qualify, please?
I didn't know if there was a question, was there?
Could you rephrase the question?
The question is, leave to one side what Mr. Hegarty said. Isn't it right that the choice is there for many, if not for all?
No. And then I'll explain.
Right. So you're just so the inspector has your judgments on this.
Sorry, I was just going to caveat what I've
Yeah, he just wanted to finish his answer.
Okay, sorry.
Okay, so no. During this inquiry, we heard a lot of things about, well, some people can, if they've got a disability, can go over to Barkway and go on a bus, and then some people that want to get on a mountain bike, they can just go down there and come up there. It's easy peasy on a Brompton and whatever the situation is. But we're dealing with planning policy and guidance, and there's common ground between us that there's the deficiencies in the pedestrians and cycleways. Topography is a problem, widths are a problem. Is it pedestrian? Is it cyclists? Well, cyclists would go down it even if they're not allowed. All of this sort of business. We know that there's common ground. There is deficiencies in the walkways. Evidence from Mr. Hegarty says it just doesn't give a good or a genuine choice from that area. I agree with that. And another thing I was thinking about was when people were talking about, well, you know, if someone wants to go down that route, you know, they can do if they're able and they want to be doing that. And I just thought about if you were a general person, you know, you've got some children. I'm walking down there. I've got a buggy. I've got my toddler. I want to go to school. Forget the commuting. Forget I want to go on a bike or something. I'm just walking down there. I've got the buggy. I've got a toddler. Toddler wants to ride their bike to school. Okay, a bit of a nightmare downhill. Coming up, okay, let's add that. We've got a bit of shopping. Toddler doesn't want to ride their bike anymore. I've got to pick up a bike. I've got to look after my toddler. I've got a pushchair. These are just general day-to-day people. It's very difficult to say if you're able, you can go on a bus, and if you're disabled or not able, you go on a bus. But if you really want to go down here, but generally people, you know, the normal people will be families going to school every day. Are you going to be able to do that? Are you going to be coming uphill? The problems you have with children, toddlers who don't want to ride their bike, even though they've asked you to take their bike to school and all that sort of business, you know, day to day, it's going to be, to me, a nightmare. Adding to the fact if you've got shopping, adding to the fact that people might be going down there cycling, coming down, and you're trying to go up there with buggy and a toddler. The efficiencies are clear to me on a human scale and in policy terms.
Sure, the inspector's made a note of that, but so we can say that is the type of thinking that's gone into your planning judgment. Yeah.
Yeah.
Okay. Very well. The inspector has a note of that. Now, you agreed with me that it's a continuum. It's not a pass-fail test. Some sites will be more sustainable than others. If you're going to attach the label of substantial harm to this site, Mr. Connell, what would you attach to sites where there are no bus stops, no bus services? Facilities are several miles from services and facilities. Where do you go on your scale?
That's a very difficult question to answer. I just don't know, depending on the site, depending on what's what. I don't
Well,
know.
let me put it to you that the job of a planner is to stand back and assess matters in the round and make a single planning judgment. And what you've done is to look for the ideal. And what you've decided to do is to say, there are some challenges, therefore the harm is at the top of the scale. You've not done anything more than that, have you?
Yes. If you assess or look at my proof, it's logical. It understands the benefits of this site. I've given substantial weight to the benefits. I've looked at some of the harm. I've done that planning balance as a whole, as a thought process, and I've come up, in my professional opinion, that this area, the provision of the non-transport modes is not a genuine choice, and it's fundamental to this case and that project.
Right. Well, let's just think about that a bit longer then, shall we? Let's assume that you're correct, and we take forward into the planning balance the substantial harm. Yeah, you say substantial. We say there is no breach of SP9. The officers were somewhere in the middle. They said it was moderate. Okay, but we'll take forward your substantial harm, Mr. Connell. In terms of the benefits, I don't want to spend a great deal of time on these because they're set out in your proof of evidence. They're set out in Mrs. Elsie's proof of evidence. But let's just focus on what we're agreed about. Housing, substantial weight, top of scale. Affordable housing, substantial weight. Yeah. Public open space, substantial weight, is that? Have I got that right?
See, again, this is going to be difficult. So no, not quite. Sorry, I'll start with no, not quite. In the committee report and in my assessment, I've taken market, affordable housing, mix and open space as one. Clearly, and I understand why appellants do this, they kind of try and get this mathematical equation coming out where if we can get loads of substantials and less harms, then, you know, it looks like one's better than the other, but it doesn't work that way. Open space is neutral in the statement of common ground.
I'm just looking at your proof of evidence, Mr. Connell, in terms of what's agreed. Let's do this slowly before we get confused, or certainly I will. Housing, you agree substantial weight. Affordable housing, you agree substantial weight.
Yeah.
Yes. Open space in your proof of evidence, you say, as part of the planning, the council considered open space as part and parcel to the residential development, indicating substantial weight to be accorded to collective. This is generally in line with section 2 of the statement of common ground. So are you saying that you're not attaching substantial weight to open space in addition to substantial weight to housing?
Well, This is a difficult one. Again, sorry. I can't answer yes or no on that one because in the committee report, it does say moderate to substantial. And I acknowledge that. And then in the planning balance in the committee report, it says neutral on its own. So in the statement of common ground, it also says neutral.
Do you attach any positive weight to the delivery of open space?
Yes. So what I have done has I have said that I think I have set it out. Yes, in 4.23, as part of the balancing exercise, the council considered open space as part and parcel of the delivery of residential development, including 40% affordable housing and open space. So they took that as one whole and they indicated it was substantial weight. So market housing, affordable housing and open space, substantial weight as a whole.
Right. So you're not prepared to give public open space any positive weight in its own right.
I think he
I did-
hadn't finished reading paragraph 4.23.
Sorry.
Yeah. So what I do is I set out in my proof that the committee report deals with market housing, affordable housing, and open space as part and parcel as the development, the whole thing, and gives it substantial weight as a collective.
Yes.
And that is generally in line with section 2 of the statement of common ground. And then I say, I'm mindful that there is agreement between the main parties, as set out in section 3 of the statement of common ground, that neutral weight is attributed to open space in its own right. That's the statement of common ground.
Well, I'm asking you a question now, Mr. Connell, and Inspector will hear from Mrs. Ellis on what weight she gives in her evidence. And that's what matters, what she says in her evidence. If it's going to be said to her, well, you've departed from the statement of common ground, those questions can be put to her. She can answer questions as to why she gives the weight she does. Plenty of time for the council to challenge that. Ultimately, what the inspector wants to know is what the evidence is of the planning witnesses in front of her. So I'm going to ask you one more time. We're agreed that housing gets substantial weight, affordable housing gets substantial weight. Are you saying that you attach no positive weight to public open space in its own right?
That's correct in accordance with the statement of common ground, but I do give it weight as part of the whole development as one. So it's not that I don't give it weight. I do as part and parcel as the whole development.
Understood. So that's housing, affordable housing, economic benefits. That's a positive, isn't it? I think there's you give moderate weight. You say in the statement of common ground that's it's moderate and it's common ground. Mrs. Ellis tells me it's not. In her evidence, she gives it significant weight, but we'll leave that to the inspector. But whether it's moderate or whether it's significant, it's still a positive weight, isn't it? Important delivery. Okay. Then there's an improvement of public rights of way within the site. You accepted in evidence in chief that was a benefit, and you were willing to give moderate weight to that, but you weren't. In your view, you said that you can't have that and positive weight to the triple SI because that's the same thing. You're doing that by introducing public rights of way and connectivity. Fine, I understand that. And then there's B and G, which once again is you say that moderate weight is agreed. Mrs. Ellis in her evidence gives it substantial weight, but even if we take moderate weight, once again, it's a positive, isn't it, in the planning balance?
Yes.
Yeah. Now, so we look at this, Mr. Connell, and I say to you that when you just look at the level of benefits that there are, and these are benefits, aren't they, Mr. Connell, in terms of housing and affordable housing in particular, which are central to the government's agenda of boosting the supply of housing in the context of an authority that has a 2.6-year supply of housing, which on any reckoning is very low, isn't it?
It is low, and I have given it substantial weight.
Yeah. Now, when you look at all that, I'm afraid I have to say to you that any reasonable planner would struggle to fail this application on a flat balance, let alone say that the shortcomings of the site in terms of accessibility significantly and demonstrably outweigh all the benefits. Simply not credible, is it?
I don't think I'm not an unreasonable planner. I'm happy with my planning balance.
And as part of that single judgment, Mr. Connell, have you asked how will Royston meet its housing needs? Will it have to grow? What are the other alternative locations? Is the authority being consistent? None of those questions are addressed in your evidence, are they?
I suppose not in that form, not directly. However, I have explained that there are housing allocations, but more important than that, and like I say, and I'm not suggesting you're saying this, but it isn't just a numbers game. If it was just a numbers game, then that's easy peasy stuff. Government can change its policies and say, whatever happens, get these numbers sorted. But they don't. We do have to have these tug of wars with the planning balance. I've looked at that, and we have to consider, yes, but the substantial weight has to go to the market housing, substantial weight has to go to the affordable housing, but these people have to live there as well. These people that we're giving weight to still have to live here, and you want to make sure that it's a good environment and they have a good choice of sustainable transport modes.
On the matter of consistency, Mr. Connell, you will have noted that RY11 was allocated by this local planning authority, and it sits right next door to this site, similar distances and the same topography down Barkway Road. Are you able to explain why that is considered to be sustainable, but this site isn't?
Well, it's not part of the issue of being sustainable. I suppose the question is, or the answer is, it was only 13 houses. So when you're dealing with the difference of 280 houses and the kind of access issues of 280 houses compared to up to 18 houses, it's a different beast.
It's not those, Mr. Connell. That can't be right. Because if you think about it, the benefit of 280 houses is a lot more than the benefit of 18. But in terms of the harm, the policy test must be the same. Either people are going to be given, on your analysis, we say there's nothing wrong in terms of accessibility, but either people are to be given a genuine choice or they're not. Are you suggesting to the inspector that because only 18 people or 18 families are going to live there, it doesn't matter whether they have a genuine choice?
Well, in terms of the genuine choice, don't forget SP9 only kicks in at 100 dwellings. So you wouldn't be assessing that allocation under SP9.
Well, I'm going to leave that with the inspector in terms of accessibility, and we'll come back to being with Mrs. Elson in closing. So one last topic, if I may, Mr. Connell, which is I've got it under the heading of miscellaneous, but this is the whole debate about the link through Shrubbery Grove, which you focus on to some extent in your evidence. So a number of points. Firstly, you appreciate, don't you, Mr. Connell, that the appellant has consistently stated throughout all of the documentation, is all there in front of the inquiry, that the improvement of this link is not necessary for this site to comply with SP6 and SP9. That an improvement will increase the number of people who would otherwise use it, but it's not critical. That's the position we've always taken. You appreciate that, don't you?
Yes, I do appreciate that. But can we look at those policies? You said SP6.
Yes, SP6 and SP9. I said it's not necessary. Well, our position is that this site complies with SP6 and SP9, and that's always been our position in terms of the Barkway Road corridor.
Okay.
Yes. So, secondly, do you appreciate that the idea to upgrade it came from the local highway authority and the planning officers and not the appellant?
Sorry, I didn't hear. Could you say that again? Sorry.
The idea that it could be upgraded came from the local highway authority and the planning officers, not from the appellant.
Okay.
Yeah. Have you seen that in the paperwork?
I don't recall seeing that, where it came from, where the idea came from.
Okay. Well, Mrs. Else will explain that, and it's in the documentation. Thirdly, do you appreciate that we, the appellant, agreed to upgrade it if the officers got the consent of the town council? And they did initially get the consent of the town council, didn't they?
There has been, I have seen some emails, and I have heard that from the town council that they didn't agree to it. I don't know what the ins and outs of it were, but
Well, if
I
you don't
didn't really
know,
deal with that.
yeah. Well, I did take the inquiry earlier to the document written by the town council themselves, where they said that if permission was granted, they would cooperate with the access.
Okay.
And fourthly, it's right, isn't it, that when the town council decided to resile on the agreement, the local highway authority and planning officers maintained their support for this proposal, didn't they? Because they accept that whilst an improvement would be nice to have, it's not critical to compliance with SP9.
Well, I don't. The highway authority wouldn't have assessed it under SP9.
That's not the thrust of my question, Connell. The thrust of my question is that with or without the improvement through Shrubbery Grove, the local highway authority and the planning officers remain in support of this proposal, didn't they?
Yes, I believe so. Well, I think at the beginning they had some issues. I don't know how it turned out. I think overall they were in support, although accepting that it didn't comply with LTN 9 something.
Now, I want to then consider with you a situation where permission is granted, and I'd like you to look at CD 3.8 again, which was the report to committee, and it's PDF page 65.
Could you direct me to a paragraph number, please?
I'm just going to try and find it myself. I seem to have lost it. Just give me 1 second. You're gonna have to give me some. I had it here, and I should have highlighted it.
I have absolutely no idea, but I'm guessing maybe 4.3.105?
4.3.105.
May 105, maybe.
I'm at 4.3196. I must have got the reference completely wrong. But in the committee report, the officers consider the impact of improving the link through Shrubbery Grove, Mr. Connell, and they give it some careful consideration, and they say that there is no evidence that upgrading the link would have any significant impact on ecology. Do you recall that?
On ecology?
Yeah.
As it stands, I'm assuming.
No, if you upgraded it, if you upgraded the link.
Could you direct me to that paragraph, please?
Well, that's the difficulty I'm having. Green Walk Plantation. Yeah, it seems to be in the wrong. Yeah, I'm afraid I can't find it at the moment. I'll have to spend some time looking for it, but I did find it. So all I can do is say to you that in the report to committee, the position of the planning officers was that they've looked at this and that they felt that the improvements could be made with no meaningful impact on ecology. Now, in the light of that, yeah, in a situation where planning permission is granted, and I don't know whether it will be, I just want to consider what is likely to happen. We know, don't we, that this is an improvement that is supported by the sustainability officer of the council. Yes.
Sorry, is it worth I am taken to, because we've assumed something here, and I want to make.
Well, if
sure-
I'm wrong about it, then the question will be ignored, won't it? So I'm putting to you the proposition that in the report to committee, in a reference I can't find at the moment, the officers were of the view that the improvements could be made through Shrubbery Grove with minimal impact on ecology. So that's the proposition. If I'm wrong about that, Inspector will scrub it out, and my friend will say I was wrong about that. 43160. Just give me 1 second. Mrs. Else may have found it. There we are. Thank you very much, Mrs. Else. So it's CD page 56, ma'am. There's a heading conclusion on ecology in BNG 43160. Yeah. What we actually see there is that a condition requiring the approval of the active travel and pedestrian routes of the Greenway Plantation and Grange Bottom informed by surveys is considered reasonable and necessary in relation to BNG. The proposal, so that goes on to BNG. But there was another a paragraph I found. But just take it from me that there was no evidence put forward in front of the local planning authority that upgrading or improving the link through Shrubbery Grove would create any meaningful ecological harm. Yes?
Yes, based on whatever was submitted.
Yeah. Now, we know that this is a link that is sought in the SSSI mitigation strategy as well, isn't it?
I think it needs to be before the witness that.
Right. So if you go to Mr. Simpson's evidence, we discussed this yesterday, that in the Thursfield Heath mitigation strategy, one of the things which is encouraged, or what the people are looking for, is a link, east-west links through the site connecting to the Greenway Plantation. That's one of the links that is thought to be a good idea and should be pursued. And you can see that CD 5.5, which is the Thursfield mitigation strategy. Dr. Simpson quoted. And if we go to page 52,
Yeah.
that was the page we were looking at yesterday. So there's that link shown. This is what Mr. Paul was asking Dr. Simpson questions about. There's a link shown, new links, improvements, the red arrow. And we see, I think the text addresses this as well earlier. And what it's looking for are these east-west links, yeah, to take pressure off the heath.
Yeah.
And the reason that I take you to this, yes, just for your reference, so that you got the full picture in front of you. It's a bit further down from the diagram on page 54, paragraph 5.5.12, Mr. Connell. To the west of Barkway Road, a bridleway footpath run broadly northwest to southeast, linking from the residential areas, providing access to the wider countryside towards Royston. To the east is a further footpath known locally as a plantation walk, runs from close to the town centre south before awkwardly doglegging west of the A10. However, there is an absence of east-west connectivity, and new links should be investigated and provided, connecting the permissive route around Burlows to these rights. And that's what the red arrow is pointing to. So the reason I ask you all of this, Mr. Connell, is this. So assume that planning permission is granted. We know that this is a link that's sought in the triple SI strategy. We know that it's an improvement that's wanted by the local highway authority and the sustainability officer of the council. And we also know, don't we, that one of the objections of the town council in their long list of objections was based on lack of accessibility, wasn't it? That's right. You've heard from the town council. You've been at this inquiry, Mr. Connell. One of the complaints they make about this site is that it lacks accessibility by non-car modes, don't they?
I don't recall. I don't recall what they said, to be honest. I'm sorry.
Right. Okay. Now, if we put all of those things together, if permission is granted, can you think of any reason why the town council would block a link or block an improvement, given that the officers support it, the highway authority supports it, the town council itself wants to improve accessibility, and it furthers the triple SI strategy? Can you think of any reason why they would block the improvement of that?
No, I don't know why.
Yeah. I mean, really, they'd be cutting their nose off to spite their face, wouldn't they? They'd be saying, permission's been granted, but we don't care. We don't care that people are living there. We're not gonna allow any improvements through Shrubbery Grove. Can you see any sense in that?
It's difficult for me to say in a professional capacity. What?
As a professional planner, can you see any sense? Can you think of any logical argument
I can't
they
see
would
any
have?
planning
Hmm?
issues. No planning issues.
No.
Why they would do that.
Well, thank you very much. Thank you, Mel.
Before we wrap up this session, just a few moments ago, there was a paragraph number that we were unclear about. That was relating to the improvements on Shrubbery Grove, the effect on ecology, and it was a paragraph within the committee report.
Yes.
Can I ask that over the lunch adjournment we find that and allow Mr. Connell an opportunity to respond?
Yes, certainly.
Yeah. Okay. So we'll have a 1 hour adjournment and then we will continue, wrap up that final bit. So it's 12:22. We shall resume at 1:20.
Thank you.
Sorry, Inspector. Am I still in the? Yeah.
Yes.
Oh,
Yep.
of
The
course.
rules about talking to
No
people
talking.
apply. Yep.
I've just found it.
Highlight it.
If I can. Mr. Connell, if you could, sorry, just rather than having it hanging over, so I won't
Yeah.
come back. My learned friend can,
Prize resumed.
yeah.
Please
My learned
continue
friend can
to
then
talk. Yeah.
move on to examination, re-examination. So it was page 55 of CD 3.8. If you could just go back to CD 3.8, which was the report to committee. And on page 55 is paragraph 43159. 43159. And there's a series of bullet points under the heading of ecology update. And it's the 1, 2, 3, 4, the fifth bullet point. It says the additional proposals to provide active travel routes between the application site and existing development to the north by way of a pedestrian link to Grange Bottom and pedestrian cycle routes to Shrubbery Grove have been subject to sensitive preliminary design, taking account of the existing ecological constraints. While this demonstrates that the ecological effects of the cycle connections are likely to be negligible and that the ecological integrity and function of both areas of existing woodland are unlikely to be harmed, further information and details need to be provided. So that was what I had in mind when I said to you that despite the position the town council now take, the fact is that they did consent to this, and whilst they now complain about ecological harm, that certainly wasn't something that was accepted by the planning officers of the council.
Correct.
Well, thank you very much.
Thank you.
Mem, if you have any questions, I've only got 3 questions in re-examination, so
Oh, okay. You happy to continue?
Yeah, sure.
Yes. Okay, we'll continue then. I did have a question. And that was, you talked about the harms that are not set out in the reasons for refusal, the landscape and the agricultural land harms. Are there any policies that would be relevant? Do those harms result in any policy conflict?
No.
No policy conflicts. Okay,
Well,
but there would be harms.
I suppose there are policy. Are there policy conflicts? They're harms. They're not a policy conflict that would result as a reason for refusal, but they're obviously policies. But
There are no relevant policies that you're aware of.
No, no.
Okay. That's all I have. Yes.
I'm just going to take you to one document, Mr. Connell, so this won't be too painful. You were brought to I think it's the Wendover, it was Inspector McDonald's decision. Westbury, I apologize, CD 6.4.
Yes.
And if you can turn to paragraph 8, where the inspector sets out the main issue there. You got it?
Yes.
So that says the main issue, single. This is whether the site is suitable for the proposed development, having regard to the council's settlement strategy.
Yes.
Is that similar to the main matters before this, Inspector?
Not quite. We have the issue of the non-transport modes, and we have the issue of outside of separate policy area.
Thank you. Second question. I quite enjoyed this where you were asked to go into my mind. Your evidence was that you would find reason for refusal to, I've a note, you would find it difficult to defend on its own. You recall that?
Yes.
And so in that case, setting that to one side, if in a finely balanced planning decision, if that's tipped one way or another in the planning balance by a matter, would you agree or disagree that that would be a determinative factor?
Agree.
Thank you. And final question, the green walk plantation lack of ecological harm or mitigatable harm. You were here for Mr. Frisby's evidence and the notorious condition 34. You recall that requires the steps to be removed from the green walk plantation.
If possible.
If
I think,
possible.
I think that's what it says. If or where possible or something like that. Yeah.
I'll take your word for it. For these purposes that we can assume or not assume. And Mr. Frisby's evidence was that it would definitely require removal of more trees.
Yes.
So would that change what the evidence in the officer's report was based on?
Yes.
Thank you.
Includes, that's obviously arboricultural stuff, ecology, potentially B&G, all different things there.
Thank you very much, Mr. Connell.
Thank you.
Thank you, ma'am. And that is the evidence for the council.
Thank you, Mr. Connell.
Thank you.
We will now adjourn for lunch and return at 1:30. Thank you.